guess we're gonna go with a part 2 on this. I guess I'll name this video Construction of Statutes. And here I'm gonna go through some of these states just to kind of go a little deeper in your remedy when it comes to holding public officials accountable when it comes to using, interpreting the terms that they're using in their paperwork when they're using it against you, dragging you into this commercial setting, and you don't know what you're doing. You don't understand the rules. We know that we don't understand the rules, but instead of us reading the laws to find out what the remedy is as to why they're able to use these statutes against us, and we do nothing about it. You know what I'm saying? We instead of us reading these laws within our states, I'm sure they got federal laws according to this too, because they wouldn't have it in every state and they don't have it federal too. So I'm gonna look that up in a minute. But this is right here, what you see on the screen right here is North Carolina. And I'm going to read just some of these, not all of it, not the whole thing. As you see, this is chapter 12, statutory construction. And you can, I prefer to read this part right here, subsection 12-3, rules for construction of statutes. Since we're talking about construction of statutes, some states are more detailed in their, in what they're saying than other states. That's why I don't mind going to other states to see exactly what they're going to say concerning the interpretation of the statutes. Because a lot of times we really don't understand what the fuck they be saying in the paperwork, but we pretend like we do know when we don't know, and we try to play the game the best way we could, even in our ignorance, and most of the time it works to our disadvantage because we really don't know how to play the game. We're not trained to play the game. They're trained to do these things when you're dealing with attorneys and judges and higher ups in different companies that are doing finances, when it comes to doing these long finance, like consumer finances and stuff like that. They use these words, these terms that mean something that they don't mean what we think they mean. Like when we're at home talking to our buddies in a private setting, those terms mean something totally different, and we were raised to think that. So when we receive a paperwork that uses the same English language that we use on a day-to-day basis, but you could tell it's for business, but you don't know the words don't mean the same thing they would mean if you said it to your homeboy, your homegirl. So I thought it'd be good for me to go into another video, kind of go into a few states. I'm going to be doing, this is North Carolina. I'll be doing California and also Texas. So right here, North Carolina, in the construction of all statutes, the following rules shall be observed unless such construction would be inconsistent with the manifest intention of the General Assembly, or repugnant to the context of the same statutes. That is to say, singular and plural, masculine, gender, etc. Every word importing the singular numbers number only shall intend to be implied to several persons or things, as well as one person or thing. And every word importing the plural number only shall extend to be applied to one person or thing, as well as to the several persons or things. And every word importing the masculine gender only shall extend to be applied to females as well as to males, unless the context clearly shows to the contrary. Notice they make sure they put that in there. Okay, so they're making sure that there's a meeting of the minds when we're using this, when they're using this language. Okay, when we use this anyway. Let's keep going. Authority to 3 or more exercised by majority. Do I want to read this part? This might not be as important. Well, it's probably important, but I'm gonna read it anyway. All words purporting to give a joint authority to 3 or more public officers or other person shall be construed as giving such authority to a majority of such officers or other persons, unless it shall be otherwise expressly declared in the law giving the authority. That's what they talking about. They want to be clear right there. They put that part in there. I want to you see right here, it's got month and year. Is the, as you see, this is the definitions. Where is it? No, I don't say definitions right there, not on this part. But as you see, in these words right here, you see right, you got oath and sworn, leap year, how counted, they're very clear. We don't see this when we receive like summons to come to court, the answers to certain things, someone claiming that you owe a debt to them, or you, some type of whatever it is, a claim that's brought against your name. These things are not, we don't see this section in none of the paperwork. You see how they define these words, what they mean? It's person and property. The word person shall extend to be applied to bodies, politic and corporate, as well as to individuals, unless the context clearly shows to the contrary. See? Unless the context clearly shows to the contrary. The words real property shall be co-extensive with land, tenements, and hereditaments. The word personal property shall include monies, goods, chattels, choses in action, and evidences of debt, including all things capable of ownership, not descendable to heirs at law. The word property shall include all property, both real and personal. So we never see this stuff in our paperwork. We never ever see this stuff, and it's their job as public officials to clear up what it is they mean by these words. I would start with the first thing. Why is my name in all caps? Why is that name in all caps? What does that mean? What does that represent? What does it represent? These types of things you need to be asking. When people want to do business with you, they try to conduct business, but yet they expect it to be a meeting of the minds. When we're in these court settings, when we're conducting business with public officials, you see all these words, they're all being defined. The word widow or widowers means surviving spouse of a deceased individual. Okay? And see, if you don't see individual in here, I read individual twice in one of these definitions. I don't know which one, but it lets you know when you don't see an individual, they'll tell you. If you don't see if they don't say, if you don't see individual written nowhere else in here, then it's gonna be taken as you meaning that it's taken on the ordinary meaning. So we got to get out of the habit of every time we see a word, we want to pick it apart and say it means something that it don't mean. Because if they didn't define it to mean something totally different, then you're gonna go with the ordinary interpretation of it. So we see individual written on here. A lot of times we've read in other codes where it says individual, and you look up and it got in their definitions area, individual is a corporation, or individual is a some type of person or some type of fictitious entity. And so therefore we run every time we see the word individual, and that's not what we're supposed to be doing. When they define these words, if it doesn't define it in the definitions area of that title where you read that, then you're going to go with the ordinary definition. And that's how we're supposed to be interpreting these statutes. Okay. Fees and charges, I don't think that's not relevant. That's not relevant. Okay, now let's go to the next one. This is California right here. I want to show this here, saying construction of statutes, the intention of the legislature, and the construction of the instrument, the intended parties, the construction of the instrument, the intention of the parties, is to be pursued, if possible, and when when a general and particular provision are inconsistent, the latter is paramount to the former. I mean, it's superior to the first thing that they said. Okay, so a particular just so you see that for yourself. Let me see. superior, supreme, same thing. Okay. So a particular intent will control a general one, okay, that is inconsistent with it. So it's always good to get a good interpretation of what the hell they talking about. What are they talking about? Let me see if I need to go further with this since I'm on California. Let me see. Interpretation of language. Is that where I was just at? Let's see. Construction of a statute or instrument. I think that's what I was just reading. The language of a writing is to be interpreted according to the meaning it bears in the place of its execution, unless the parties have reference to a different place. See, you're supposed to make sure that they interpret what the hell they said when they put something in writing on there. You gotta hold them to that. And this is what the laws are telling you they're supposed to do. Contradiction of terms and of agreements by evidence of prior agreement and contemporaneous oral agreement. Let's see, evidence explaining. I'll let y'all read that on your own. Let's see, office. Here we go. Let me see what this says. Constructive statute of an instrument. Get back up here. Is this what I just read? Nope, I didn't read this one. Okay, in the construction of a statute or instrument, this could be a summons, or any paperwork you receive from a public official. In the construction of a statute, or instrument, the office of the judge is simply to ascertain. That means to be sure of. Let me see. Y'all can't see that screen right now, but it says to be sure of. But anyway, to find out, I will go with that one there. But up at the top, it says at the top, you can't see it in the screen because I got it cut off. But it says to make sure. That's what it means. Or to find out. Simply to find out and declare what it is, what is in terms or in substance contained therein. Not to insert what it has been, or what has been omitted, or to omit what has been inserted. Say and where there is several provisions or particulars, such construction is, if possible, to be adopted as will give effect to all. Okay, and making sure it has to be a meeting of the mind. You got to understand what it is. All parties are supposed to know what the words mean, what's being said, what the intentions are. Intent the parties in this construction. Is that what I read earlier? Consistent with, I think I read this one. Did I? Let's see. The construction of statute, intention of legislature, and the construction of the instrument intended the parties. Yeah, I did read this. Pursue the parties. Yeah, I read that one already. Let's see. What else? Circumstances. The instruments made. Circumstances of the instrument made. Presumption terms of writing. It might go a little deeper with California. For the proper construction of an instrument, the circumstances under which it was made, including the situation of the subject of the instrument and of the parties to it, may also be shown, so that the judge be placed in the position of those whose language he is to interpret. Okay. That's what I just read. 1861. The term of the writing are presumed to have been made, are presumed to have been used in their particular and general as acceptation. But evidence is nevertheless admissible that they have a local, technical, or otherwise peculiar signification. And were used and were so used and understood in the particular instance, in which case the agreement must be construed accordingly. I remember me mentioning a signification in the previous video when I was talking about that. They say it's supposed to have signification when it comes to the words that they're using with the paperwork. They got to signify what it is that they mean when they're saying what they're saying. can't just use these words, and they can and use them and just and railroad you if you just let them. But if you don't call it out and you don't show them what the law, basically invoke these laws, what these state laws are saying, and they have to by law make sure that you understand what they're saying. Words of instrument, partly in writing and partly in printed form, in consistent terms of agreement intended in different sense by different parties. Let me see what this is. Construction of a written notice. Statute instruments, successful as true interpretations. I'm gonna read that one in a minute and see what this says. When the terms of an agreement have been intended to in a different sense by a different party, by the different parties to it, that sense is to prevail against either party in which he supposed the other understood it. See, that's what it's supposed to be. That's what we're talking about, the meeting of the minds right there. That sense is to prevail against either party in which he supposed the other understood it, and when different constructions of a provision are otherwise equally proper, that is to be taken which is most favorable to the party in whose favor the provision was made. So, as you see, they're talking about the meeting of the minds. They're just kind of going in details in each one of these laws. Let's see, construction of a written notice, as well as every other writing, it is to be construed according to the ordinary acceptation of the terms. See, in a written notice, say thus a notice to the drawer, that's the one who draws it up, or endorser of a bill of exchange or promissory note, that it has been protested for want of acceptance of payment, must be held to import that the same has been duly presented for acceptance or payment, and the same refused, and that the holder looks for payment to the person, to whom the notice was given. Okay, I'm sitting here thinking about some stuff while I'm reading this part right here too, because I don't want to talk about that. I keep that to my damn self. 1866. I'm gonna go to Texas after this one. When a statute or instrument is equally susceptible of two interpretations, impressionable, likely or liable to be influenced or harmed by a particular thing. That's what the definition says. You only see the thesaurus, but I'll see the definition that's right above that. But anyway, to two interpretations. One in favor of the natural right, and the other against it. The former is to be adopted. I like that. Okay, now let's see. Here we go. Well, they sure weren't saying that when it came to my son, but I guess I can. Well, I guess yes. Yeah. No, I digress on that one, because if I didn't do the DNA test, how can I enforce a natural right? Because I gotta prove that the child belongs to me. So I get that. I stand corrected. Okay, now let's go to Texas. This is Texas. I'll make sure y'all understand. Yep, Texas right here. It's Texas statute. It was this one little part I wanted to read to y'all right here. It's section 312.002, meaning of words, except as provided by subsection B, which is right here. This is subsection B. All this is subsection B. Except as provided by subsection B, words shall be given their ordinary meaning. Remember, I told y'all, if you see individual or person or what, if they don't put in the definitions area of that code, in that title, a difference between like they defining it to be something mean something different, you're going with the ordinary meaning of it. The same the meaning that you would understand if you weren't reading legalese. It's like you see United States and you don't see no definition that's saying it's different from a federal corporation. Then you're not going to think it's a federal corporation because you see it there. So you got to know how to use a little common sense when you're reading these statutes and not be so caught up with these absolute strict teachings that we've been subjecting ourselves to for years over the internet, because these people teach absolutes and we don't change how we seeing things because we don't understand. You got to use ordinary meanings. If this right here say except as provided by subsection B, words shall be given the ordinary meaning. Now the exception is this right here, B. If a word is connected with the use if it's connected with Mike, slow your ass down. If a word is connected with and used with reference to a particular trade or subject matter, or is used as a word of art, the word shall have meaning given by experts in the particular trade, subject matter, or art. Particular trade, subject matter, or art. So experts, whoever you get. So you got these public officials who are using these words, these certain legalese terms. They have to, if they're considered experts at this, they're trained to do this shit. So I would see them as experts myself, because say if you're dealing with an attorney or a lawyer, attorney or a judge or any public official who's been in the game for a long time, and they're using this wordplay on a daily basis for years at a time. At some point they become experts. They get trained to do it. So it says that the word shall have the meaning given by the experts in the particular trade, subject matter, or art. So if they're using words of art, it's talking about subject matter, jurisdiction, or whatever, particular trade, that's in consumer, that can even be consumer law. These people have to use the words. They have to use the meanings. They have to give you this is by the law. You see this written right here in the Texas law. They have to give you the meaning of the words when they're using these words. So if they don't give you the meaning of these words when they try to conduct business with you, there can't possibly be a meaning of the minds. So if you get up with a court order against you, and they never made it clear what it is that they meant by the paperwork, by the things in the paperwork. You never saw once any definitions area where they actually showed you what these words meant. They just sent it to you, had you served, and moved forward as if you automatically knew this stuff. And then we get so caught up on saying ignorance of the law is no excuse. It got nothing to do with knowing the law. It's about understanding the interpretation of the language. That's two different scenarios. You can know the law and don't know the language. You know what I'm saying? Like, we know right from wrong. We know certain things that we shouldn't be damn doing. At the same time, how somebody communicates something to us could be a totally different situation. So this is what's going on when you got paperwork that's being sent to you, and somebody telling you, and they're using words like summons and appear. Use summons to appear. I'm like, what the fuck? What the fuck does that mean? Why you can't just say come to court? Come to this building at this particular date at this particular time. We need to talk about the situation we got going on here. They don't use plain English. They use those words of art right here, but they don't tell you exactly what the fuck those words mean. What do you mean by I'm summons to appear? Last time I heard you summons you summons spirits. I mean, that's the ordinary meaning right here, ordinary meaning, because you never gave me the meaning. You know what I'm saying? Say the word shall have the meaning given. I was never given the meaning of summons to appear. This is a summons to appear. So I would be thinking, if I didn't get that, I'm like, what does that mean? You know what I'm saying? So they're supposed to give you the meaning of what the words mean. What does that mean? So anyway, because nobody's ever summons me in my private capacity. I'm chilling at home. My mom say when I'm at home with mama, when I'm growing up, mama never said I'm summoning you to come here for a minute. you know. She just told me to bring my ass here. So that's all it was to it. But anyway, I don't want to drag this video out. I'm gonna get on out of here. I think I talked long enough. But hopefully y'all get it. We get it. We gotta start making these people hold. You can actually get remedy out of that, because if they conducted business with you and they never followed the law with giving you the meaning of the words that they use, and they got orders against you. They got you in contracts and kind of situation that you never had any intentions on being a part of, and you feel like you locked into it. You have a remedy in that, but you got to be proactive. You can't don't just let people just railroad you and don't do shit about it. You know, if you don't do nothing about it, then oh well. You can't complain about something if you ain't gonna do nothing about it. So, but anyway, I'm gonna get on out of here, y'all. We'll see y'all in the next video. Bro.